Hello, welcome. Thank you for joining us this evening. We have a special treat this evening that's an addition to follow up from our workshop last week where we did choice and control in supported decision making. David is going to follow that up with alternatives to guardianship. And we'll get started here in just a few minutes. We're going to give everyone a chance to join, to get their audio connected before we begin. All right. Well, so thank you for joining us. This is Alternatives to Guardianship, maintaining choice and control for individuals with decision-making challenges with a focus on independent housing. David, we're lucky enough to have David able to put this together for us, and he will be presenting.
I would like to introduce you to David Gates. David Gates has represented and worked with individuals with developmental disabilities, their families, and support groups in federal and state court administrative agencies and the Pennsylvania legislature since 1976. He has presented at 25 workshops on housing options throughout the state since 2010. He is currently the content expert consulting with Vision for Equality, Bus Housing Myths. He was a member of Office of Developmental Programs, Information Sharing, and Advisory Committee. He served as the project lead for the Pennsylvania Developmental Disabilities Council grant on housing transition tenancy, sustaining provider training. David was a project lead on the Urban Housing Options Demonstration Project grant. David has participated in the development of 7 licensed residential micro boards, a home owned jointly by 3 waiver participants, an apartment house developed with subsidized units, specifically with a preference for individuals with developmental disabilities. Other family and self-advocates directed housing models. Ladies and gentlemen, David Gates.
Well, thank you, Ernie. I hope I can live up to that hype. So, last session, you heard from self-advocates and families about the importance of choice and control and how the charting the life course tools can help a self-advocate in identifying a vision of their good life on which to base their choices, including choices regarding housing. In this session, I will try to address some of the perceived barriers to individuals exercising that choice and control. So there's 2 main myths, since this is a myth-busting seminar, that I think really get in the way of individuals with disabilities and their families fully utilizing the variety of tools out there to assist in decision making. The first myth is that individuals with intellectual disabilities or autism lack legal capacity to make decisions on their own, make their own decisions. Well, next slide. The answer, the fact, there we go, is that legal capacity is not determined by the individual's IQ score or their diagnosis. It actually is an individualized determination that looks at a number of factors, including whether less restrictive alternatives are available to thereby avoid a judicial determination of incapacity, which is part of the guardianship process. Okay, myth number 2. Parents of an adult with intellectual disability or autism must get guardianship in order to have any legal say in her son or daughter's services, finances, or medical care. All right, so what is the fact? The fact is that there are several legally recognized tools for decision making that do not require guardianship, and I will be presenting on several of those. I won't say that I have every one of them here tonight, but I'm going to cover a number of those tools. So these tools support self-advocates in making their own decisions and allowing parents and other supporters and family members to assist those adults in making those decisions, including decisions regarding their housing, without resorting to guardianship. So why not guardianship? Well, I'm going to read to you from the Pennsylvania Guardian Handbook, and this is an official publication of the Office of Elder Justice in the Courts, part of the Administrative Office of Pennsylvania Courts, which just came out last year. And they quote, "Guardianship takes away many rights and freedoms from an individual and must only be considered after all less restrictive alternatives are considered and fail to meet the needs." Okay, this is the courts talking. Other reason, a guardianship involves a judicial declaration, a judicial order that an individual is legally incompetent to exercise choice and control over many important aspects of their life. A recent amendment to Pennsylvania guardianship statute, there is a specific state law that sets up guardianship and all the conditions. And this was amended just last year. And one of the amendments in there states that a determination of incapacity, that's a legal term, is separate from a determination of whether a guardian should be appointed. So guardianship is not legally required always for an individual who might be deemed to lack legal capacity. They are two separate things. Another problem is that under guardianship, a court may restrict the individual's rights to vote, to go to school, to become employed, or even get married. For other areas listed in the guardianship order, the choices of the guardian supersede the choices of the individual who is under the guardianship. So service providers, financial institutions, medical providers, and others can disregard the choices and wishes of the self-advocate. This also means that for housing, a person with a guardianship cannot sign a lease on their own or make their own decision where to live or with whom. They would also not be able to own a house or a condo in their own name. So that's the problems. So what are the alternatives? Well, here's a list of the ones I'm going to talk about tonight. And again, these are not exhaustive, but I think these are probably the top ones to mention. Surrogate for waiver services, healthcare power of attorney, healthcare representative, mental health power of attorney and declaration, financial power of attorney, representative payee, joint and custodial bank accounts, ABLE accounts, and supported decision making. So, surrogate for waiver services. So, for those of you who are on the ODP waivers, now I'm talking about consolidated waiver, community living, PFDS, and adult autism. Those waivers specify that the individual who is on the waiver, if they choose to self-direct some of their services, they have the right to select a surrogate. That is the term used in the waiver, a surrogate And a surrogate is someone who is their representative regarding those services. Now, it is the choice of the self-advocate whether they want to have a surrogate and to choose who that might be. There is no finding of legal capacity necessary. You don't have to go to court. There's no petition. That is something that is done with your supports coordinator. The only qualifications for a surrogate is that they are designated by the individual, they be at least 18 or older, and the individual who is for whom this person will be surrogate is not already under a guardianship, in which case, if there is a guardianship, the guardian is the de facto surrogate. Next slide. Now, the surrogate must, and I'm quoting here from the waiver, effectuate the decision the participant would make for himself, herself. That is, they have to take into consideration what and try to figure out what it is the self-advocate would want. They have to accommodate the participant, that's the person on the waiver, that they can participate as fully as possible on all decisions that affect them, give due consideration to all information, including recommendations of other interested and involved parties, and embody guiding principles of self-determination. This is right from the waiver. Now, the only other mention of authority of surrogates beyond the self-directed services is for appeals from service denials. So the waiver says that surrogates have authority to file appeals on behalf of the individual they are representing. Now, as a practical matter, most supports coordinators and administrative entities will recognize family members as surrogates. But I am speaking here where it's actually in black and white in the waivers. Okay. So next we move on to powers of attorney. Now, Pennsylvania has two different statutes that set out two different kinds of powers of attorney. One is for healthcare decisions, and the second is for financial management. So I'm going to first talk about the healthcare power of attorney. So a competent individual may appoint in writing another person who is called the agent to make healthcare decisions on their behalf. However, this kind of power of attorney, this healthcare power of attorney, only becomes effective when a treating physician determines that the individual is no longer competent unless the written power of attorney states otherwise. So this is very different than the financial power of attorney. That power of attorney, that can exist while the individual is fully competent. The person doesn't have to become incompetent for that to go into effect. But for healthcare powers of attorney, unless otherwise stated, they only go into effect when that individual is no longer competent, meaning no longer able to make healthcare decisions on their own. The healthcare agent under the power of attorney has broad powers to make a variety of healthcare decisions, including the power, and this is right out of the statute, the power to authorize admission to a medical, nursing, residential, or similar facility. The statute says that in the absence of instructions, that would be instructions from the self-advocate, the healthcare agent shall make healthcare decisions that conform with the healthcare agent's assessment of the principle, that's the self-advocate, preferences and values, including religious and moral beliefs. While the statute does not specify exact language that must be used in a healthcare power of attorney, it is still my advice that you have this drafted by an attorney. Now, healthcare representatives. This is also part of the same statute that sets out healthcare powers of attorney. This one says that an individual of sound mind, and we'll get to that in a second, what that means. An individual of sound mind, quoting from the statute, may, by assigned writing or by personally informing attending physician or healthcare provider, may designate one or more individuals to act as their healthcare representative. The healthcare representative has the same authority as a healthcare agent under a power of attorney. That means they have very broad authority. If the individual is certified incompetent by an attending physician, in that case, the physician under this healthcare representative statute may rely on the medical decisions of a family member or other adult who has knowledge of the principal's preferences and values, including but not limited to religious and moral beliefs, to assess how the principal would make healthcare decisions. So this is someone who is not able to designate a healthcare representative. This can be done under this statute at the point in which the physician no longer able. Goodness, hold on a second. Is no longer able to make decisions on their own regarding their health care. The statute sets out a list of priorities as to who the physician should rely upon for making those decisions, those healthcare decisions. Now, getting back to this issue of sound mind, what does that mean? It means that the individual, despite receiving appropriate medical information, communication supports, and technical assistance, is unable to understand the potential benefits, risks, and alternatives involved in a particular healthcare decision, and is unable to make that decision on his or her own behalf, or communicate that healthcare decision to any other person using whatever communication supports they have available. Next slide. Okay, there is an ODP bulletin that talks about healthcare representatives. This is specifically, however, for folks who are in ODP facilities, group homes, and ICFs. And I've listed there a website where you can go to get even more information about healthcare representatives. Okay, next. Now, there is yet another statute that provides for mental health advance directives. And this law enables individuals who are
David, we lost your sound.
There we go. Will enable them their choices regarding their mental health treatment known to treatment providers in advance of a time when their mental illness makes them unable to make those decisions. The individual can make their choices known in advance by writing what the statute calls a mental health declaration. The individual can also appoint a mental health agent, which is basically like the agent under a power of attorney, who can make decisions about their treatment when they are unable to do so on their own. Okay, next slide. Properly executed, the declaration and appointment of agent, collectively called the Mental Health Advance Directive, is binding on mental health treatment providers unless against clinical practice or not covered by insurance. For more information, Disability Rights PA has an excellent guide on these mental health directives, and you can find that at the link that I've placed in this slide. All right, so we've covered the healthcare powers of attorney. We've covered the mental health powers of attorney. Now we're going to talk about the financial powers of attorney. So remember, these are separate. When you say a power of attorney, need to be specific, because a power of attorney, if it is done as a financial power of attorney under a specific state law, does not authorize the agent to make healthcare decisions. That's a different statute, so that really needs to be done separately. So now we're talking about the financial powers of attorney. This is a document by which an individual with legal capacity authorizes another person, called the agent, to make certain decisions, financial decisions, and enter into certain agreements or contracts on the individual's behalf. Now, under any of these arrangements, while the individual is competent, the individual retains full decision-making authority and can countermand the decision of the agent or terminate the agent's power. However, the individual granting this power of attorney must have legal capacity at the time the power of attorney is signed. So what is this legal capacity? I talked about it before in the context of the healthcare powers of attorney. For this, I want to emphasize, and for all of these powers of attorney, whether it's healthcare, mental health, or legal power, the financial power of attorney, they are not based on IQ. There's no cutoff at which point says you are no longer legally competent to sign a power of attorney. Again, it is an individualized determination. Number two, it's not based on your ability to talk, provided as long as the individual has some other means of communication that does not rely on the person who's going to become the agent to assist with that communication. You really can't have the agent do the communication, because that would be a direct conflict of interest. The individual has to be able to express their intent independent of the person who will become the agent by whatever means they have. And they should be able to demonstrate that they know and trust the person who will be their agent, that they understand that this person will be making certain decisions on their behalf, and that they understand what kinds of decisions the agent will be able to make. Now, how do you figure this out? Well, as a practical matter, because powers of attorney, financial powers of attorney, they're very formalized. Unlike the healthcare powers of attorney, I mean, there is a form that you can use in the statute. It's not that formal, but financial powers of attorney are very formalized. There is a very specific notice with exact language that must be given to the individual who's signing a power of attorney. There's specific language beyond the notice that actually has to be in there. There's signature requirements. There's witness requirements, notarization. There's a lot involved. So they really should be drafted by an attorney. As an ethical matter, as a practicing attorney, it is my obligation, our obligation as attorneys, to make an initial determination as to competency before we draft a financial power of attorney. So as to who's making that decision, initially it is the attorney who is drafting the document. And I would say that the key elements are the attorney being able to get some clear sense that the individual knows and trusts the person who's going to become the agent, that they are able to express in some fashion that they understand that this individual is making certain decisions, and broadly what those decisions would be about. And so that would be the key elements here. Now, for the financial power of attorney, these powers of attorney by law are called durable powers of attorney, which means by law they continue in effect no matter what happens to the individual in terms of their competency later on, as long as at the time of signing they were legally competent. Now, the only real restriction is if a person is under a guardianship, they are not legally competent to sign a power of attorney. Other than that, it really is that individualized determination. What happens if an agency, bank, or medical provider refuses to accept the power of attorney? State law allows the agent to seek a court order compelling the acceptance of the power and get money damages for the refusal to accept it. What can agents do under financial powers of attorney? There's a long list. I don't have it all in here because a lot of it has to do with wills and inheritances, contracts, and the like. But the key ones, I think, for folks tonight are they can receive government benefits on behalf of the individual, which really means apply for those government benefits. They can engage in banking and financial transactions on behalf of the individual. They can sell or purchase property, both real property, that is houses, and personal property like a vehicle. And they can create a trust or withdraw money from a trust. Now, I'm not going to talk about trusts, by the way, tonight. There's a lot of material you can find on trusts, but I have to say that trusts I do not see as a way of really supporting self-advocates to make their own decisions, because under a trust, the financial decisions are made by a third party who is a trustee. That third party must take the financial well-being of the individual into effect. They are called a fiduciary, but that does not mean that they have to agree with the individual's choices. So I don't see trusts as really an alternative or a means of ensuring choice and control for self-advocates. Okay, next slide. So now we're going to move on to something called a representative payee. And this is a specific provision with Social Security. Now, you can have a financial power of attorney, but that isn't really accepted by Social Security. You have to have something very specific called the representative payee. And so under this provision, an individual with a disability would have their Social Security or SSI benefits paid to the representative payee rather than being paid to that individual directly. Now, this is important for those individuals who lack capacity to make a power of attorney but do not require or have a guardianship. If Social Security Social Security is the one who selects the representative payee if they determine the individual is incapable of handling their own benefits. And Social Security has a list of priorities of who they will look to serve as representative payee. In determining whether the person is unable to handle their finances, the Social Security will consider a statement from a treating medical professional or signed statements from people such as relatives, close friends, neighbors, or landlords. And if the Social Security selects the representative payee, those Social Security benefits will be paid to the representative payee either in their own account or a custodial account. The representative payee is required to use that money for the expenses of the Social Security or SSI beneficiary. They're no longer required to file a yearly report like they used to, but they really should put this money in a separate account so that they can account for it, because the law still is in effect that they have to use it for the financial needs of the individual, the beneficiary. Social Security has online a handbook that goes into a lot more information, and Section 1601 of that handbook will tell you all about representative payees. Okay, next, custodial and joint bank accounts, another financial tool. So if the individual has a representative payee and lacks capacity to grant the power of attorney, the rep payee should have a Social Security deposited into a custodial account that is in your name for the supported individual, because it makes it much easier to account for how the money is used and report on that money to both Social Security and to the waiver, because waiver will count assets in the name of the individual. So having that separate account makes it very easy to say, okay, here is the bank account, the custodial account for this individual. Here's the amount in there. You get a bank statement, do that annually, and their countable assets have to be below $8,000 for a waiver, under $2,000 for SSI. Okay, joint accounts may be useful for individuals who do not have a representative payee, but may need support in handling their funds. However, with a joint account, waiver will generally consider half of that joint account to be a countable resource for both SSI and waiver. So parents who have a joint account with an adult child should be careful about putting their own money into that joint account. Okay. Now, ABLE accounts. Hopefully all of you have heard about ABLE accounts, but a brief reminder, these are accounts authorized under federal law, and our own Senator Casey was instrumental in getting the federal law enacted for this. And ABLE accounts are good savings plans for individuals with disabilities when those disabilities occur before age 26. They allow the individual to save money without affecting their benefits. So I mentioned that there's a resource limit, $2,000 for SSI, $8,000 for waiver. Any money put into the ABLE account does not count against those resource limits at all. But in addition, unlike trusts, of an ABLE account, if the self-advocate opens the ABLE account themselves, they have control over their own money. They can control how the money is invested, and they can control how the money is spent when they choose to withdraw it. So unlike a trust, this really is a way of enabling choice and control over finances for individuals with developmental disabilities. For those individuals who are unable to handle their own funds, families can open and control the ABLE account, and they do not need a guardianship to do so. The other useful thing, we're talking about housing now, is that money withdrawn from an ABLE account can be used to pay monthly rent or mortgage or other housing costs. That is an issue with special needs trusts. There are restrictions about using special needs trusts for ongoing living expenses, but it's not a problem for ABLE account when we're talking about housing costs. For more information about ABLE, Pennsylvania has a great ABLE program. It is run by the State Department of Treasury. I highly recommend it. You don't have to use Pennsylvania's ABLE program, but there are tax advantages if you do, because anyone who contributes to it gets a tax write-off on their state income taxes by using Pennsylvania ABLE. And Pennsylvania ABLE has a great website with loads of information, and they hold regular seminars, webinars to explain this in detail. And their website is paable.gov. All right. Supported decision making. Now, many of you may have heard of this. What exactly is this? It is not, at least in Pennsylvania, a legally specified form of decision making, unlike the powers of attorney that I mentioned, unlike representative payee, unlike the ABLE account. Those are all specified in either state or federal law. This is not really specified in state law, although it is in some other states. But what it is an approach to supporting individuals who have challenges in making, articulating, and implementing decisions about their lives. Under this approach or this concept, the IQ or legal capacity are totally irrelevant. The diagnosis is irrelevant. It is not a specific planning tool, but a concept aiming at having a team that will assist the individual in making decisions needed to realize their vision of a good life as expressed through their charting the life course tools. Now, the individual, next slide, please, chooses a team of supporters, such as a circle of support, who will agree to assist that individual by, and these are not tasks that are specified in law. Quite frankly, these are tasks that are my opinion, having read a lot of materials on supported decision making and been involved with some families who have used supported decision making, that it is my conclusion that these are the kinds of areas of support that are vital in supported decision making. To present options, alternatives, and resources, to explain risks and benefits, consequences and responsibilities for each potential decision, to answer questions from the self-advocate, to assist the individual in weighing pros and cons of their decisions, and assisting them in utilizing a means by which they can express their decision and communicate that decision to providers, government agencies, medical providers, and financial institutions, and then assist that individual in ensuring their decisions are implemented. Now, next slide, there's no formal structure that's required for the team and no required qualifications for team members in Pennsylvania. There is one family in Pennsylvania that I've worked with who created a corporation whose board members serve as the team for supported decision making, and they have imbued the bylaws of their corporation with supported making decision concepts, so that their team, which is the board of directors, understands they have all this written out in their bylaws as to how they will support this individual in that individual making their own decisions. A written agreement is not necessary. As I said before, this family chose to do that. I think that's a good idea, but it's not necessary in Pennsylvania. But there are a number of states who recognize those written agreements, including Minnesota, Indiana, Alaska, and the District of Columbia are just a couple, and there are several more as well. However, it is my advice that when you do supported decision making, that the team members document how the individual reached his or her decision and how that individual expressed that decision, in order to avoid team members having some liability for those decisions. In other words, it's got to ultimately be the individual's decision. We're supporting that individual, but we're not making that individual. I think that documenting that this is the individual's own decision really helps avoid the team members facing some kind of liability for those decisions. Now, there's a lot of information out here about supported decision making. I mean, I have sat through webinars, 2-hour webinars about supported decision making, both national and state, and I've corresponded with some folks, including the legal director of the supported decision making organization. And so there's just a ton of information out there if you really want to dig into that. There are other states who actually have forms that you can use. There's organizations that have come up with forms as well. There's none that has been specifically approved under Pennsylvania law, but if you want to do this, you certainly can look for those forms. And I've listed 5 websites, and there are more, but there are 5 here that I have actually used, where you can get a lot of information about supported decision making. Now, I said that supported decision making is not formally recognized under Pennsylvania law. However, it is referred to in the state guardianship law. The amendments that I mentioned that were made to this law just last year. And those amendments, I'm going to actually quote from them because they're important. That petitions for guardianship under the new amendments must allege specific facts. So when you do a guardianship, you have to file something called a petition with the court. And it's a written petition, and it has to allege a whole bunch of things in this written petition as specified by the Guardianship Act. So the amendment says that this petition must allege or include specific facts demonstrating that less restrictive alternatives were considered or tried and why those alternatives are unavailable or insufficient. And certainly supported decision making is one of those less restrictive alternatives. And the statute, the amendments go on to say that not only must the petition show that these other less restrictive alternatives have been considered, but that the court, meaning the judge, shall identify the less restrictive alternatives that are available and sufficient to enable the alleged incapacitated person to manage their personal financial resources or meet essential requirements of physical health and safety. So it has to be in the petition. That is, the lawyers have to put it in there. And then the judge, when the judge is ruling or looking at the petition, the judge herself or himself must look at less restrictive alternatives. The intent, because I am quite familiar about the discussions that went on in the 2023 amendments. The intent was to force people or agencies seeking guardianship and judges to seriously consider alternatives, including supported decision making. Next slide. Now, although there isn't a direct legal authorization, there is an interesting sentence in the Guardianship Act, the 2023 amendments, which I think can be used to provide some legal foundation for supported decision making in a case-by-case basis. And I'm going to read that to you. And that the judge can grant an order that may assist the respondent. The respondent is the person for whom a guardianship is being sought, that is the self-advocate, and any supportive and substitute decision makers involved to effectuate the respondent's decisions with third parties. Okay, that's legal mumbo jumbo. But what I think that could take to mean that a judge could order that where there is a supported decision-making team in place and they're going in front of the court, that the court could order, say, in lieu of a guardianship, I will issue a court order that will give legal authority to this supported decision-making team to validate the decisions made by the self-advocate with the support of the supported decision-making team, that would actually be a court order. That's my opinion. I think it's worth trying. So this is a way, I think, of trying to get legal recognition of supported decision-making. Okay, so I don't know if we have time, if there are any questions that people want me to ramble on about, this would be the time.
The only question that I had come through was from Ingrid. is, does the durable power of attorney encompass both?
Both the healthcare and the financial? Okay, so the the durable power of attorney refers to the financial power of attorney. Now, I will say that the healthcare power of attorney generally is durable in that, absent anything else in the healthcare power of attorney, it only goes into effect when the individual becomes incompetent. So, in that regard, both are in effect when an individual who was competent at the time of signing becomes incompetent. So, I would say that the answer is yes, it encompasses both. Now, there you could have these two put together in a single document. Um, I would say from the estate planning attorneys that I've worked with, in fact, the one who's actually done my will and power of attorney, she separated those into a healthcare power of attorney and a financial power of attorney, and I think that is wise. You It also enables you to choose. You might have somebody different to handle your finances than handle your medical. And that's a way of ensuring that as well. And quite frankly, typically when you do the healthcare power of attorney, you will do something called a living will or advanced directive. That's typically done at the same time. I didn't talk about that because that's really an end of life thing. And hopefully we're not at that point yet. Some of us may be closer than others, but that's what I wasn't talking about tonight. But they're typically done together.
Tina, did you have any questions come through?
I do not have any questions in my chat.
I
I see.
do have another one if
Yeah.
if you
Yeah.
in my chat. From your experience, how do you determine if a non-speaking person is capable of a power of attorney?
Right. So I would look to see if they have another form of communication. And if so, is there someone other than who's going to be the agent who can support them in using that alternative or augmentative communication? I mean, although there isn't anything statutory that says the agent can't help with that. In my opinion, that's not really ethical, because we want to make sure that the decision which gives these authorities to this third party, that is a decision that the individual makes freely and of their own accord. And given that some forms of augmentative communication rely on an individual to physically assist the self-advocate, we don't want to muddy the waters with that being an agent. So that would mean, first of all, having some means of explaining the idea that someone will make some decisions on your behalf for you, and then seeing if they can acknowledge, yes, I understand that, by whatever means they have, whatever communication device they use. And if yes, then we move on. I would ask, do you want X person to be that person who will make some of these decisions for you? Yes or no? They can answer. Are you okay with them making decisions about your money? Yes or no? Okay. And we go on that way so that they can answer in a yes or no fashion if the questions are phrased in a way that elicit a yes or no answer. But one by one, figure out through a sequence of questions by which I would determine, yes, this person has sufficient capacity, regardless of their IQ or their communication challenges, to grant a power of attorney. If they are unable to use any kind of assistive or augmentative communication device, then frankly, I don't think I would do a power of attorney.
Okay. I think Tina has unmuted Mary Hartley.
Hi, thank you, David. This has been
Hey.
great. I
Thank you,
appreciate
Mary.
all the information. I just, as a parent, I just want to share this information and maybe get some thoughts on this. So our attorney wrote the medical and the mental health power attorneys, as separate documents.
Mm-hmm.
And our children signed them and we signed them. And then they said that we had to replace those annually. That's a very expensive process with an attorney. Is there
Right.
anything else we can do short of literally verbatim rewriting those and having somebody else witness them? Can they re-sign them with their signature and their date? So we don't have to spend that money annually to have an attorney review that.
Replace them annually.
Yeah.
Okay, so I'm going to start first with a disclaimer that a state law and powers of attorney are not my primary area of expertise.
Okay.
I mean, I have read the laws.
Mhm.
Obviously, I've read the laws
Yeah.
for years, and I read them before I did this presentation. I did not see anything that required annual reviews. I can tell you that the attorney that my wife and I use, uh, who is an expert in special needs planning,
Mm-hmm.
never said anything to us about annual reviews, and so I honestly I don't know where that came from.
Okay.
Again, I could have missed something because that's not. I don't want to go toe to toe with this attorney to say, oh yeah, he or she is wrong.
Mhm.
But I, I have not heard anything about reviewing it. I mean, financial plans should be reviewed annually, but
Sure.
the legal documents, unless something changes in terms of, for example, who the agent is going to be,
Mhm.
I, I'm kind of at a loss
Okay.
as to why.
Okay. I'll ask another attorney maybe on our behalf, but
Yeah,
thank you so much.
I think this is a case where a second opinion is definitely called for.
Okay, good. Thank you. I appreciate that.
Sure,
David, I have a question in my chat.
sure.
If a family has completed both of those legal documents, a durable power of attorney and a healthcare power of attorney, in another state, are they good in Pennsylvania?
Wow. Um, there are some issues with the healthcare powers of attorney. And as far as the financial powers of attorney, what I can tell you what my attorney told me is that, in her words, that complicates things. So I would say I would strongly advise that you have a Pennsylvania attorney review the documents. The powers of attorney, and the reason is the powers of attorney are based upon two specific state statutes, okay? And those statutes can differ somewhat from state to state. So you want to make sure that the power of attorney that was drafted in another state fully comports with Pennsylvania's two statutes, the healthcare statute and the financial statute. And so having that reviewed, I mean, I think it would be worth having the review. And the review may be, this is okay. We don't need to do another one. Hopefully you have an attorney who's not going to try and run the meter and say, oh yeah, you got to do a whole new one. But I really think it would be worthwhile having a Pennsylvania attorney, or at least an attorney licensed practice in Pennsylvania, review to make sure it complies with our statute.
So one more question out of chat. And if you want to, you can still put your questions in chat and we'll follow up with you. But out of respect of time, we're getting close to 8 p.m. This next one is, if you already are the representative payee for an individual, should you obtain a financial power of attorney?
Should you obtain?
Yes. Do you still need to get a financial power of attorney?
Okay. Um, no, you do not, as long as the bank will allow you to open a custodial account with that. That's fine. The issue may come up is if you need to enter into some kind of a contract using the individual's money, you would not have legal authority to do that. But if you're basically using that money, the money being direct deposited, because Social Security does direct deposits, into a custodial account that you don't need um, the financial power of attorney to set that up, and then you're just paying bills out of that account. Say you have a custodial checking account, or you're using some other bill paying mechanism to just pay bills. You would not need a financial power of attorney to do that.
Thank you so much. Do you
Sure.
have any final thoughts or anything you want to wrap up with this evening?
Well, I think the final thought is this whole program, our programs have been trying to bust some myths, and each program we look at some myths and we try and show what the facts are. And so I would just go back to our initial myths here, just to reiterate, because I think they're really important. If you could go back to the beginning, just go through them one more time to sum up.
Okay.
Um,
So if we could do the
I can
QR
just,
code real quick,
yeah,
and I'll take us back to the beginning. This is how we're able to bring these wonderful projects to you, and how David is able to continue to share his wealth of knowledge with all of us, and how this is able to be offered for free. This is we are funded through Pennsylvania Developmental Disabilities Council. This is Vision for Equality's housing myth busting. And are you able to put that link in chat, Tina?
Which, oh, the code?
Yes, the link in chat for
Yes,
this
I
one.
think I can.
Okay, great.
yeah,
Now I'm going to take
we,
us back to the beginning.
right, slide 2. We really
Yep.
appreciate that. It really helps us. You know, we're funded by Developmental Disabilities Council. This is a requirement of theirs, so we appreciate you filling out these questionnaires, and they're pretty short. So again, we want to bust the myth. Don't look at IQ or diagnosis when you're determining whether an individual has legal capacity. Okay, it's an individualized determination. Individuals may have capacity to make some decisions and not others. It's not a black and white kind of thing. And secondly, there are a number of tools that we can use, both for the individual and for those supporting that individual, that can help them make their own decisions. And I'm not going to go through the whole list again, but there is a whole list of tools here. And that these tools are really better than guardianship. Guardianship has some serious downsides for the individual, really does strip away many of their basic civil rights. So we want to encourage using these other tools. Not all of them are going to be applicable or appropriate, but there's a whole bunch out here. And very often by using several of these tools, you can really enable an individual with developmental disabilities to make their own decisions with support. And that's basically the bottom line.
Oh, thank you, David. Carrie, it is not letting me put the link in chat.
Did it not share when I put it back to the myths?
I
Sorry
don't
about
think it
that.
did.
I was wondering. I was like, all right. I am going to get the link since it didn't share anyway, and that way I can share the link. Thank
Oh,
you for
I think
being
Chris
patient
just
with
put it
us.
in. Chris, I think you just put in the link. Thank you so much.
Is it our link?
Yes, it is. So the survey really does help us moving forward. We appreciate you taking the time to do that.
All right, somebody want to mention the next exciting topic?
Yes.
Right. Yes. All right, can everyone see it now?
Yes. Thank you.
There we go. All right, go ahead, Ernie. What have we been working on?
Our next workshop is for Vision for Equality Bust Housing Myths is addressing safety concerns. And it is Wednesday, November 6th at 7 p.m. Again, that is Wednesday, November 6th at 7 p.m.
The day after Election Day, so please go out and vote.
Absolutely.
Yes. If you have any questions that we didn't get a chance to answer, please put those in chat. While we have been on, you should have received an email from Cordy Miles with the PDF of the slides this evening. Sorry, we didn't get those out a little bit earlier. If you did not receive them after checking your junk and spam file, please reach out and let us know. We can be reached at, Joan, do you want to take that?
Our number is 215-923-3349. And our email is pafamilynetwork@visionforequality.org. And visit us at www.visionforequality.org.
And we really appreciate everyone being here. I'm going to go ahead and put back up the satisfaction survey. Again, we don't have any control over this. This is very strictly tied to our funding. And we are so grateful that you are here and that we've had the opportunity to share this information with you. Thank you, David.
Thank you, David.
Thank you, David.
Thank you, David.
My pleasure. Look forward to everybody on November the 6th, right?
Absolutely.
Yes.
Okay.
Addressing
Safety concerns. Thanks, everyone. Have a great
and thank
evening.
you all for coming tonight.